Let's go on the record on cause number DC 209666, 7700 John Carpenter LC versus Ben Randolph. Counsel, make your appearances.
Your Honor, Counsel Bill Richmond for plaintiff 7700.
Honor, Chase Garrett for all of the defendants, Agency Entourage LLC, Patriot Leasing LLC, and Ben Randolph individually.
And I've already reviewed all of this, but I'm perfectly willing to, I kind of think I know how I'm going to rule, but I'm perfectly willing to let you guys argue however you'd like.
Thank you, Your Honor. I'll highlight the key points. There's a number of issues with the response and the fact that it focuses largely on, if not entirely on affirmative defenses, but I'll keep it to the high points and the ones that militate for the granting of this partial motion for summary judgment. Without any dispute, the parties know that as of April 2020, there was valid enforceable leases where payment was not made after that. There's no dispute that the tenants vacated the premises, but in a belated opportunity to try and get out from under that, they have claimed that the fire suppression system and other issues related to their affirmative defenses are sufficient for them to be able to raise a separate fact issue on those defenses and therefore defeat summary judgment. But of course, it's important to first go through the breach of contract on the first instance. We agree that there's a breach, that there's a valid enforceable contract, and we agree that the other elements were largely met, that there was an injury, that there was a breach. The only real dispute back and forth is to the extent that the response can be seen as saying that landlord did not perform. There's really no dispute that everything was done up until April of 2020 by the tenant, other than they decided to vacate in 2020. They didn't give the necessary notices that they were required to. They didn't backfill like they were required to under the agency lease. But really the meat and potatoes of the response to the summary judgment isn't about the rent. It isn't about the breach of the leases. It isn't truly about the guarantee, which is unconditional and waives all defenses. What it comes down to is the 3 or 4 arguments as defensive matters and whether or not those suffice to create an adequate fact issue, which they do not. Working through those as laid out in the response, Your Honor, the affirmative defense of prior material breach, while summarily covered in just a few paragraphs in the response, does not actually raise a fact issue. As correctly noted in the response, there are a number of factors that the court must consider and look at when determining whether or not there has been a benefit deprivation under those 5 factors. So for example, the failure to receive any benefit or the amount of the benefit that was deprived, compensation, whether or not there's compensation available for the benefit that was allegedly deprived, whether there was a forfeiture, whether the plaintiff can cure, and whether there was good faith and fair dealing. Here in this case, it's important to understand the context, which is that Ben Randolph, the guarantor, is the person who sold this building in its condition just a few months prior to the current landlord, my client, 7700 John Carpenter. He is also the person who is the guarantor of these leases, both of these leases under Patriot and agency, because he was a principal and connected with those 2 entities. So when we look at the good faith and fair dealing, the ability of the landlord to come in and say, wow, I'm completely shocked. I had no idea what the condition of this building is important context when looking at those factors. One completely unaddressed at all in the response itself. And again, remember, when proving or attempting to plead and prove an affirmative defense, it is the non-movement's obligation to meet its pleading and proof standard in order to defeat summary judgment. But here are the facts that we do know. And we do know that, as admitted, the tenants were there from January through April, despite knowing that there was a red tag, despite complaining that there was a red tag on the fire suppression system. They've said, well, we were there the entire time. They have not provided any admissible evidence of any of these other factors. For example, that they suffered a forfeiture. You have inadmissible statements about certain employees being disrupted during their work, but no actual statements from those employees, which we've objected to in our reply. the actual response itself doesn't go through any of those factors and thus doesn't satisfy the standard. But a couple of key exhibits in the response really put the nail in the coffin on this defense of prior material breach. First of all, there's Exhibit B2. Agency Entourage sent a letter in early April saying we are going to cease operations because of the orders and the impact of the orders under COVID of Judge Clay Jenkins. It doesn't say anything about we can't operate our business, we can't do anything because of this fire alarms, we feel unsafe, we got to get out of here. We can't be here. None of that. And in that time, they vacated. That's undisputed in the records when you combine both the plaintiff's record and the defendant's record in this case. In Exhibit B5, they talk about how there was an order eventually came down that said from the fire marshal, oh, look at all these issues that exist with this system. You need to engage a fire watch. But one of the emails actually submitted by the defendant shows that a fire watch was put into place. Nothing in those orders say that there was a forfeiture of the ability to use that space. There was no order saying that people could not occupy the space and use the space. There's no actual admissible evidence of any deprivation of the benefit other than speculative hearsay and conclusory statements that we have objected to with regard to those affidavits. But perhaps most importantly, look at the response at page 17, paragraph 43, where the tenants admit in their pleading that they continued to operate their business, albeit with some disruptions. But a mere disruption does not create a fact issue as to whether or not a tenant could, outside of the terms of the lease, somehow breach the lease and then move out. No chance to cure, no chance to fix, no chance to do anything. Now, I know what the response will be in this argument. The response will be, well, you took these 3 months. You didn't actually do what you needed to do to the repair. In fact, you lied to us about taking any effort to repair. That's the crux of the waiver argument, which is the next defense, that there was a right to repair and that right was waived. But again, one, they admit that they continue to operate their businesses, but two, their own evidence from the defendants, these tenants, shows that they knew that the repairs were occurring, that the fire system issue with the fire panel was caused because of a leak in the roof, that leak was identified, a contractor brought out to fix it, that the panel issue was then rectified, and then additional sweeps were taking place to take care of fire extinguishers, fire suppression systems, and even the alarms. Now, the simple fact of the matter that we're going through these is all just a distraction from the actual breach itself. They wanted to have a reason to leave based on their letter from April 2nd, and they claimed that COVID is what disrupted their options or disrupted their operations. Then a few weeks later, they sent a new one where they again sent COVID as the reason, and then tag on at the bottom, well, now we feel unsafe. But they knew about the fire suppression issues for 4 months at that point, and yet they continued to be there. The very definition of prior material breach is that it deprives you of the benefit, and yet they don't have evidence that they were deprived of the benefit. They have an admission that they continued to utilize the space. Second, when it comes to the waiver, there is no waiver, and in fact, that argument just simply doesn't support. The waiver would have to be a waiver of the right to receive rent. That is not the way that the waiver defense is being used here, and so as a matter of law, doesn't actually apply. But finally, under waiver, they have to show an actual intent to relinquish the right to receive rent payments. There is no support under the law, much less under a fact issue, that taking some period of time within 90 days to discover a roof leak, causing a fire panel issue, to then go and rectify those issues is an evidence of actual intent. There is not even a fact issue raised by those conclusory statements. Finally, when we get to the Estoppel argument, they talk about really that there is some kind of false representation made with actual knowledge and intent, but they don't show any evidence of what the actual intent would be. They merely throw out arguments to say, well, because they knew that we were having some disruption, that must have meant that they knew that our business couldn't operate in this space. Well, that runs counter to the evidence that they have provided themselves as the tenants. There's no evidence of intent. There's no fact issue created by this affirmative defense pleaded in the response. But the final element on Estoppel is that there must be a detrimental reliance. detrimental reliance under established Texas law, as we cited in our reply, it means a change in position. They didn't change their position. They operated prior to the red tag. They operated after the red tag. They operated during that entire period. There's no actual showing of a detrimental reliance. There's no showing of intent. There's no showing of actual knowledge. And for all of those reasons, there is no estoppel defense. And again, a reminder on the burden on the non-movement claiming an affirmative defense. They are required to prove all of those elements that there's actual genuine issues of material fact to raise that defense. The final one that they mention is a failure of condition proceeding. Essentially, this is just a procedural argument. Their argument is that if there is no agency or patriot liability that established as under summary judgment, then Randolph as the guarantor is not liable. However, I will direct the court to two very important provisions in the guarantees. The first one is let me pull that up. The first one is in Exhibit A1, Exhibit C, which is the guarantee. Section 1 says that the underlying liability is not required for these tenants. It's an unconditional guarantee, as noted in Section 1. In Section 3, it actually says that no action is even required against the tenant to bring about the liability of the guarantor. Second, the fact of any defenses by Randolph as guarantor has been waived. Section 6 says that the guarantor waives any defenses, not just of the guarantor, but of the defenses by the tenant to these amounts. And again, the flow of liability here is that Randolph is the guarantor for the agency lease. Agency is not only responsible for its own amounts, but it's also responsible for the Patriot lease, which was the existing lease in place at the time of the property switching ownership. In the end of the day, Your Honor, there is an opportunity for parties to plead affirmative defenses and show genuine issues of material fact, but one or more elements of each of those defenses has not been proven or not been properly pleaded, or to be able to show a genuine issue of material fact under the summary judgment standard. Given the lack of dispute on the rent not being paid, the injury and the breach occurring, and the enforceability of these leases and the guarantor, this court can confidently grant summary judgment on this partial basis that there is a breach of contract under this lease, and that the guarantor Randolph is liable under the plain terms of this unconditional defenses waived guarantee.
Response?
Your Honor, I'll be very brief and try to make this very simple. Mr. Richmond is trying to do surgery on an ankle when the leg has already been amputated. The court will recall on March 31st of 2021, almost a year ago, the plaintiff filed a motion for summary judgment, a no evidence motion for summary judgment on the defendant's counterclaims and affirmative defenses, which they claimed there was no evidence of agency entourage's affirmative defenses or its counterclaim. There's another tenant, the upstairs tenant is Patriot Leasing. They're not subject to today's motion. The court denied that motion, and in doing so has impliedly ruled that agency entourage has a breach of contract on file that will go to trial because they have met and shown at least a scintilla of evidence of each element of that claim. They have affirmative defenses that the court has found at least a scintilla of evidence exist on, including prior material breach, waiver, estoppel, offset, frustration of purpose, and failure to mitigate. What they're now trying to do a year later, we'll fast forward to March of 2022, is say, oh, hey, give us summary judgment on our affirmative claims. Well, that's impossible. The court has already found a scintilla of evidence on the affirmative defenses. The court has already found a scintilla of evidence on the counterclaims. So what they envision is we'll have a trial where the defendants go in on their counterclaims, but they're starting at a negative number. That doesn't really make sense. It cannot be done. The prior material breach is probably the most glaring affirmative defense, and this comes down to this issue of the fire protection system was not working. The most important thing to remember here is that the Dallas Fire Department, the marshals, vacated the building and ordered it unoccupied. We took the deposition of the plaintiff's corporate representative last September of 2021, 17 months after agency entourage vacated the property, and the fire protection system is still inoperable. The landlord can still not receive a CO. They cannot release the property. I think that's pretty good evidence to our failure to mitigate defense, our offset defense, prior material breach defense. This is simply not a claim where
I
the
guess
court.
the main thing I want argument on is I tend to agree with you, but the failure of the condition precedent.
Let me refamiliarize myself with that one. 1 second.
He says that you've waived all of your defenses, I guess, when it comes to the guarantee.
Yeah, I think his argument is if you look in the guarantee itself, it says that the guarantor waives defenses, which is a pretty typical clause to put in a personal guarantee. However, there still has to be something to guarantee, right? That means agency entourage must be found liable for rent. If they are, then the guarantor has no defense. He owes it. But they're sort of getting the cart before the horse here because they don't have a judgment. They don't have an amount due. Why? Because of the affirmative defenses that agency entourage has pled. Why? Because of the counterclaim that agency entourage has. It would make no sense to go into a trial about a lease, starting with one person, the guarantor, who guaranteed amounts due under the lease. And you, sir, we're going to start with you owing everything under the lease. Then we're going to find out whether the tenant actually owes the money or not. I just don't think that can happen. So in this situation, if agency entourage is found to owe money, I'm going to have a hard time coming up with a defense for an individual guarantor. I think we all know that. But there is no amount owed by agency entourage.
Is the guarantor making any additional defenses that are unrelated to the defenses related to the tenant?
No, he's simply saying, I don't know anything because agency entourage doesn't know anything. I'm guaranteeing what agency entourage owes. Agency entourage doesn't know anything.
Is that correct, Mr. Richmond?
No, Your Honor. When you look at the way that they have argued the condition upon which liability is based, that's page 17 of their response. Their argument is that because of the defenses of the tenant, the guarantor does not owe anything.
That's exactly what he's saying.
Okay. Sorry,
maybe I'm not asking it very well, but let me rephrase it. So what I'm trying to get at is I'm going to deny this motion for partial summary judgment. I really think I've already heard most of these issues before, but the one issue that I did want to kind of delve into is if the guarantor is trying to make some other argument saying, hey, I don't have to guarantee this, even if the tenant owes it, I don't have to pay it, then I think he would have waived that in the contractual defenses. So to the extent there are any claims like that, then I would grant partial summary judgment on those for waiver, but I don't know if he has any of those types of defenses.
Well, Your Honor, I think then what we're really talking about on that guarantee issue is the language of what the guarantor has waived, because the section 6 in the guarantee says guarantor waives any defense by reason of any legal or other disability of tenant or any other party to the lease, and further waives any other defense based on the termination of tenant's liability for any cause, as well as any presentments. That's the key language, waives any other defense based on the termination of tenant's liability for any cause. All of those other defenses, even if the court were to find that they're valid, and I would request.
So you're saying that even if the tenant doesn't owe, the guarantor would?
The guarantor still owes those amounts because they're arguing this based on a defense. And it says, guarantor waives any other defense based on the termination of tenant's liability for any cause. And under that language, it's an ongoing unconditional guarantee. I would say one quick thing, because I know that the court is looking at these facts and I can hear the persuasion in Mr. Garrett's argument here, but he mixes up the standards. This isn't a no evidence motion for summary judgment. That's a scintilla standard. The standard for asserting an affirmative defense to defend against a traditional motion for summary judgment is the traditional summary judgment standard. So while Mr. Garrett has made a convincing argument and through very light evidentiary, even if the court ignores our objections, all he's done here is satisfied the scintilla standard. But the scintilla, if he's even done that, but the scintilla standard is not the standard when trying to create a fact issue on an affirmative defense. That's not what it is. He doesn't cite that in his standard. He doesn't cite that in the brief. I've looked at the case law, and it's very different. Hence why they're different motions. He mentioned offset. He mentioned failure to mitigate. Those aren't defenses that are pleaded here today. What they have to be able to show is, here's the provision that you have breached, landlord, and you have created more, not just a scintilla, actually met this traditional motion for summary judgment standard.
Okay. I guess I still haven't communicated this very well, and so I'm not sure if there's any other way I could describe it. But to the extent the summary judgment would be granted, would be only for defenses that the guarantor has to collection that the tenant would not have. So if there was, for example, the guarantor tries to say, I shouldn't, even though the tenant owes it, I shouldn't owe it because, it wasn't a proper guarantee or whatever other reason, there wasn't consideration for my current guarantee, he's waived all of those defenses. I don't interpret it the same way as you, Mr. Richmond. Maybe the Court of Appeals will disagree. It would make no logical sense to me that a guarantor would owe on a claim that the tenant didn't owe. But so, Mr. Garrett, why don't you go ahead and prepare an order on this as to what I just ruled, and make sure it says at the beginning that this motion was heard on March 21st, 2022, that it may be a complete denial of the summary judgment, but that if there is something that's unique to the guarantor and their defenses and not to the tenant, I want you to include that, or I want you to include just a sentence that says, to the extent that the guarantor has any defenses that are separate from the tenant's defenses, those defenses are waived, or something like that. Does that make sense?
Sure.
So if you try to claim in the future the guarantor has additional defenses, there's already a ruling that those are waived.
I think the only thing, this is not really a defense, but there is, I think the guarantee was trailing. So I don't think it's going to be, if agency entourage owes, I'm just using round numbers, 6 years of rent, I think the guarantee was trailing as to maybe like it went away after 2 or 3 years or something like that. It's been a while since I've looked at the particular mechanics of it, but I don't want to waive that issue. I don't
think that's a defense. So that would just be the term of the guarantor, a guarantee, and I don't think that's addressed. But to the extent that they have any additional defenses like lack of consideration or whatever that they may have pled or they might plead, well, I guess I can't really rule on a summary judgment defense that hasn't been pled, but to the extent there is any defenses, those are waived.
Okay,
understood.
I don't think there are any. Just I think our answer was, defendants plural.
I still want you to include that in there.
Well,
but everything else is denied.
Okay.
All right, guys. Anything else?
Thank you, Judge.
I think that's it. We'll work on the language. Thank you, Judge.
Thank you, guys, and get that to me by Thursday.
Well, Bill, I'll email that to you by tomorrow.
Right.
Okay. Thank you. Bye, guys. And share it with Mr. Richmond.